Will be so. Good evening, everyone, and thank you for joining us in the third out of four educational evenings here in the month of May, hosted and sponsored by Down Syndrome Indiana. We're so thankful for Down Syndrome Indiana and their great team, and Stephanie Garner and team that helped put this together and made it possible. So again, Down Syndrome Indiana, just one of the amazing nonprofits that we're so fortunate to have here in Indiana in the special needs community. This evening, we will be doing a deep dive into special needs trusts, and I think you'll enjoy it a lot. There's more to special needs trusts than many people realize, and there's lots of different types of trusts, and we'll talk about those this evening. I see special needs trust as answers to problems, that is, they're solutions to problems that otherwise we experience in our special needs journey. And so they're a really good thing. I think everyone knows that as a part of participating in the series, we're extending to you a free follow-up consultation. And I see one of the names on the screen is somebody that just emailed us today to get that free consultation scheduled. And so encourage the rest of you to please send us an email and let us know so that we can get you on the schedule for the free follow-up consultation. At the end of this evening's workshop, one of the last slides will have the email information, etc. So you can just jot it down, or hopefully you're getting the pre and post workshop emails, and it can be just as easy as hitting the reply key to one of those emails back to Jamie Sturchy, our parent advocate, parent with a son with special needs, and we will get you scheduled for your free follow-up consultation. We set aside up to 90 minutes for each family, and believe me, there is always a lot to talk about. So whether you have done no planning and need to take some first steps, or whether you've done a lot of planning but want to have it checked over and looked at to make sure everything is current and on track, regardless of where you're at in your journey. You've got a newborn, or you've got a son or daughter with special needs that's plumb grown in their 40s or 50s. We help and we serve and we work with families of all makeup and circumstances. And so please let us help you. All right, I'm going to go to screen share. As we have done in past Thursdays, I invite questions. I love questions. I love participation. What we do ask is that if you want to ask a question, that you unmute yourself and ask the question, and then we'll answer it. And then if you would be so kind to re-mute yourself, and that way we won't pick up lots of background noise and that type of thing, and make it difficult for people to hear the information being shared this evening. But again, questions are welcome. You do not have to wait to the end. In fact, we've got a loaded agenda tonight, and so a good idea might be to just ask your question as it comes up. The reason for that is I'll probably have the appropriate slide up at that time, and I'm not altogether sure we're going to have more than a couple of minutes at the end for Q&A. So be bold, unmute, and speak out. Get your question out there, and we'll do our best to answer and maybe have a little fun with it at the same time. All right, I am going to go to screen share, and again, this evening is on special needs trusts. And if somebody can give me a nod, an ear pool or something that the slides are showing. Yes. Okay, I think that was a yes. Okay, good, wonderful. Thank you so much for that. And again, this evening is on special needs trusts. To introduce myself again, I'm Gordon Holmes. I'm a certified financial planner. I've been in practice for 40 years. My practice is almost exclusively focused on special needs, all forms of special needs, all diagnoses, etc., and all ages. And we serve families throughout the entire state of Indiana, most of the state of Kentucky, with offices in Indianapolis, Louisville, and Lexington, Kentucky. We're handling meetings virtually as well as in person. We are welcoming families back into the office, and also we're doing meetings virtually by Zoom. So whatever works best for you, we are happy to accommodate. And again, Special Needs Trust, providing for lifetime care and quality of life. This is our disclaimer. We worked very hard to help families, but we are not all things to all people. So we need, of course, to have our disclosures. So Special Care is a division of MassMutual, the large insurance and financial firm, and that's the division that I function through. My geography is the state of Indiana and Kentucky. I do work with families in other states because they've moved away or have relocated, et cetera, but the primary focus is Indiana and Kentucky. We address both the legal, the financial, and the government benefit issues. So there's a lot of expertise on Medicaid, Medicaid waivers, Medicare, SSI, SSDI, making government benefit decisions, making retirement decisions, disability decisions, dealing with legal documents such as estate planning documents and special needs trust that we'll talk about this evening, appealing government benefit decisions, whether it's Social Security or Medicaid administrative hearings, dealing with litigation and situations involving where someone has been harmed. It goes on and on. If it has something to do with special needs, we're in the middle of it. And we do have a network of attorneys throughout Indiana and Kentucky. There's about 12 or 15 attorneys to handle things on the legal side. So it's a comprehensive approach to all special needs planning issues. A special care planner is what I am by participating in the program. And our focus is helping families, again, with all of the issues related to special needs. I get emails every day from families from all over. We do our very best to respond and help people in their hour of need. Working currently, in fact, with a situation where someone, a divorced couple, and the father, who has rarely seen the child, who has disabilities since birth, passed away down in Tennessee. So we're working with a situation where the son here in Indiana is able to draw off of his father's Social Security record, and we're dealing with the father's estate issues. So one thing with special needs, it's always interesting, it's never dull, and every family is like a situation to unwrap and figure out, and we're delighted to do it. It's just most have not been at it for 25 years like myself, and so I'm delighted to be helpful to families. So there are 10 comprehensive life care planning steps, and next week, this is a bit of a teaser, because next week we're going to talk about life care planning and person-centered planning. So if you've ever heard those terms, life care planning or person-centered planning, and wonder what that's about, you'll want to definitely tune in next week. We will also be summarizing next week from the first 3 sessions as well. So it's a great kind of revisit some things that we've talked about throughout the month of May. And so it's going to be a wonderful workshop. If there's something that didn't click before, it probably will next week. So please make sure, same time, same place, right at your kitchen table or whatever, next week to tune in for the 4th and final of the education series here in the month of May on life care planning, person-centered planning. And there are 10 steps, as you can see outlined here. Some steps of interest would include the guardianship, which we covered in session 2. Identifying financial resources, we're going to talk about some of that this evening. How does one fund a trust? And then also preparing a letter of intent, number 6, that's a caregiver guide. While I have mentioned the letter of intent during the series, there's actually a workshop on letter of intent alone that walks through creating this owner's manual, this caregiver guide for your loved one with special needs. And so the reason I mention this is because this education series through the month of May is not the end all. There are actually about a half a dozen other workshops, topical workshops on different special needs planning issues. And I'll be delighted to come back and cover additional topics and or repeat this series, because there are always families joining the special needs community by moving in or by birth or by some event occurring. And we want to update, keep the information fresh, and continue to bring it to families going forward. Okay, review as you see at the bottom, and we do encourage people to reach out to us and periodically meet virtually or in person to review what we have put in place, because over time there are external changes like with government benefits, and there are internal changes like in the family dynamic, etc. Okay, so why set up a special needs trust? I mean, what would cause someone to be interested in a special needs trust? These are just a series of examples. One would be that an individual has developmental disabilities. Because they have some capacity or function issue, a special needs trust can be very helpful from the standpoint of maintaining eligibility for their government benefits or enabling them to be eligible, as well as having someone oversee their funds or their financial situation. So developmental disabilities is certainly a popular area from a community standpoint of who is looking at special needs trusts. Congenital disabilities such as Down syndrome, also muscular dystrophy, there's Lou Gehrig's disease, there's spina bifida. There are a lot of conditions that originate from birth where special needs trusts are critically important. Again, managing resources, eligibility for benefits, etc. Traumatic brain injury and or spinal cord injury. Like I mentioned on the plane just Tuesday of this week, the young man, 33 years of age, flying back from Florida in the seat next to me, where he talked about the many surgeries he had on his back just by age 32, and had an issue with spinal fluid leaking, and it just sounded just awful. And so we never know when some event may occur that's going to affect us that way. Medical malpractice situations where perhaps there was a botched medical procedure or situation not handled properly, and a malpractice litigation situation occurs. Personal injury liability, being the victim in an auto accident or a pedestrian struck by a vehicle, this type of thing. Manufacturer liability. We've all heard the situations with automobile recalls and cribs that collapse and just on and on. So manufacturer liability, asbestos, I mean, on and on. Lots of those situations out there. Structured settlements, which can come as a result of litigation where someone is receiving money on a structured basis or on a schedule. That income, the structured settlement, can create a problem with government benefits and can also create a problem with money management. And inheritance. Inheritances are wonderful, but if you're an individual with special needs, inheriting assets can undermine continued eligibility for things such as Medicaid, waiver services, etc. So gifts are also wonderful, but if that gift is something that Social Security or Medicaid would count as an available resource, it can be a nightmare. Medicaid and or SSI eligibility issues relating to income or resources. So, and there's more. So just lots of reasons why special needs trusts are a godsend. And you'll see in a minute that there are about a half a dozen different types of special needs trusts. And so it's not a one size fits all, but because we have these varied special needs trusts at our disposal, we have the ability to solve a lot of problems. So let's take a quick walk back through government benefits. That was 2 weeks ago. And just a reminder that government benefits fall into two major categories. One is insurance or pension type, and that's where a person is contributed to the system by FICA taxes, payroll taxes, et cetera. Those benefits are primarily Social Security disability and Medicare. Then there are needs-based benefits, and they're complements to the Social Security disability and Medicare. And those benefits are Supplemental Security Income, or SSI, and Medicaid. So we kind of divide the benefits up, because what we have to do to qualify for these benefits, as well as what we need to do to maintain eligibility for them, varies, as does the potential treatment from a special needs trust. So kind of two different channels, shall we say, and the guidelines and requirements are different with each of these. Now you might say, well, isn't everyone in category number 2? And the answer is not necessarily. So category 1 in the way of Social Security disability, as we discussed a couple of weeks ago, an individual with special needs or Down syndrome can be eligible to draw Social Security disability benefits off of their own record by simply having several years of part-time employment, or they may be eligible to draw an adult child benefit off of a parent's record. And this is really powerful. I had some people in my office just earlier today, and they brought in Social Security reports. You know, that 3 or 4 page report that you're able to pull off of the Social Security website if you have just a little bit of patience and can set up your My Social Security account and request the PDF. And so they brought it in. Did somebody have a question? Okay. So they brought in these reports and we went over them. And for this family, we added up what the dad would draw for retirement, what the mother would draw for retirement, and what their adult son with special needs would draw. And it's not unusual, but in their case, we expected the collective Social Security benefits to be about $5,500 a month. That's, again, a single household, a single family, a mom, a dad, and an adult child with special needs collectively drawing $5,500 per month. That is $66,000 on the year. That's some pretty powerful stuff. And so making smart decisions with Social Security is really important. And these decisions are not just limited to late in life, but early in the special needs journey as well. So I encourage many of you to take advantage of the free follow-up consultation so that we could have a conversation about Social Security, SSI, and SSDI, and what strategies are appropriate to enable you and your loved ones to take maximum advantage of these Social Security benefits that, again, can add up to $5,000 or $6,000 per month. It's amazing. But without knowing like whose record someone should draw off of or not, and does a spouse with a lesser income draw off of his or her husband or wife, or do they draw off of their own record? And which parent does the adult child with Down syndrome or special needs draw off of? And can they draw off of themselves and off of a parent? Well, as you can see, the questions are almost endless. And this is where the individual consultations are so powerful, because we're able to look at your specific situation, because everybody's situation is different. So the 2 types of government benefits. I want to remind everybody that questions are welcome, and we have built up to our normal attendance level, so that's wonderful. And to ask a question this evening, don't wait until the end. Do feel free to unmute, and therefore you can speak and ask your question as it comes to mind. Having the slide up that goes with your question could be helpful. And then we'll know that we've addressed your question versus running out of time at the end. Just a few did you knows. Did you know individuals with special needs who may qualify for both Medicaid and Supplemental Security Income, which of course is SSI, may not receive these government benefits if their assets exceed $2,000. I was just on the phone on a conference call with a family from Northern Indiana, literally 15 minutes before I hopped on this evening's workshop. And we conference called a close family friend and then the consumer with special needs who was using Relay Indiana. And we were addressing this very issue because he has had multiple appeals for Social Security. And he thinks the final appeal is going to happen, the outcome is going to be known next week when the judge makes a decision. And he has over $30,000 in available resources. And so it has been brought to his attention that regardless of what the judge decides relative to his medical diagnosis, his medical qualification, because of his financial situation, he will not be eligible to receive benefits. Am I making sense here? Does this make sense? Meaning he has over $30,000, and that's about $28,000 too much. Yeah. So he has been on this appeal over and over again, and he's been working at this for the better part of the last 2 years. And what a shame it would be if he finally gets a judge that agrees with him that he is disabled and qualifies for Social Security, and then because of the money he has saved, or that he had saved from when he was working some, would disqualify him from receiving the benefits he has worked for literally years to qualify for. So there are some strategies for dealing with a situation when you're over the 2,000. And by the way, if you're curious as to what assets we're talking about checking accounts, savings accounts, government bonds, mutual funds or investment accounts, annuities, permanent life insurance, Uniform Transfer to Minor Act accounts, IRAs, SEPs, Simples, 401ks if you're no longer with that employer, or even a coin collection if it can be easily converted to cash. So there are a lot of things that the government will trip you up on with regards to your loved one or family member with special needs to disqualify them. And so a part of the individual consultation is to do an inventory of what assets and incomes and resources exist to make sure that we're not violating the government guidelines or that your situation is not ripe for being turned down for benefits, benefits being discontinued, etc. So again, one of the very important reasons for looking at your situation individually, because Social Security will count all of that, what we just discussed. A strategy would be to place assets inherited, including inheritance, gifts, life insurance, etc., into a carefully drafted special needs trust. So that was the conversation we were having just an hour ago with the family from Northern Indiana, what to do with this 30-some-odd thousand dollars. Special needs trust assets that supplement the needs of your dependent and will not jeopardize a beneficiary's eligibility for needs-based government assistance, such as Medicaid, SSI, and if properly established and administered within a certain trust arrangement. So what this means is that literally the family I was talking with an hour ago, if we set up a special needs trust, the appropriate type, and we sweep this 30-some-odd thousand dollars that this young man at age 32 has accumulated into that special needs trust, then he can immediately claim poverty, and then his financial his financial situation will not rob him of the benefits that are benefited from SSI that he has fought so hard to get. All right. It does note you should work with an attorney that is familiar, of course, with special needs trusts. And that's one of the reasons that I maintain a network of attorneys throughout Indiana and Kentucky so that we make appropriate connections. So a little bit of a history lesson. Special needs trusts originate back in 1993 as an outgrowth of the OBRA 93, or Omnibus Budget Reconciliation Act of 1993. And it was a carve out, an exception that was made in this legislation because the legislation limited ability of individuals to transfer their own assets to others in order to qualify for Medicaid. So this is the very legislation that made it difficult for seniors to give their money to their children or their grandchildren, claim poverty, and have Medicaid pay their nursing home bill. So an exception was made, with the primary thought being for individuals that are a bit younger, meaning the exception is not for someone at age 80 that just simply can't take care of their stuff. An exception was made for younger individuals whose need for Medicaid was tied to a disability as opposed to old age. So this exception was known as the Medicaid Payback Trust, otherwise called the First Party Trust, and it allows an individual to receive funds in certain types of trusts while still receiving the needs-based benefits. Or you could say to have your cake and eat it too. So what is a special needs trust? And the answer is it's a means of enhancing an individual's quality of life beyond the basic food, shelter, and health care that the government is focused on. Again, the government is focused on food, shelter, and health care. Food and shelter is the SSI, healthcare, the Medicaid, of course. So for many individuals with special needs, their special needs trust is their everything else. That is everything other than food, shelter, and healthcare. It can be set up to send a dependent with special needs to camp, to take vacations, travel to visit relatives, buy sports equipment, pursue education, such as job or technical training, college, or to pay for other therapeutic needs that do not fall under day-to-day living or maintenance expenses, dental care, purchase of a home, condominium, furniture, clothing, personal items, entertainment, etc. I mean, almost anything that enhances the quality of life for your loved one with special needs. So it's like a miracle. It really is. If properly drafted, proceeds placed in the trust will not affect government benefits, as funds held by a special needs trust are not considered those of the trust beneficiary, meaning they're there for the trust beneficiary to benefit from, but they are not considered the trust beneficiary's own assets. Funds in a special needs trust are typically invested for growth and income. I'm asked that all the time. People say, well, you put it in the trust and it just sits there. And my answer is, yep, it sits there in mutual funds, stocks, bonds, investment portfolios, et cetera, growing and expanding and so forth. So we do not let trust assets sit idle. We manage tens of millions of dollars of special needs trust assets, and we're working with those accounts and those portfolios on a daily basis in order to maximize growth and opportunities for the trust beneficiary. And by the way, access is the other question I get. What happens with the money when it goes in there, and how do I access it? And the answer is, with the help of the trustee, the funds in the trust can be accessed for all those things that we just looked at. Let's see here. Yeah, there we go. Yep, all kinds of things listed there. So the trustee can write checks to pay for things, can transfer money out to pay for things. It's really very practical. These trusts can help with all kinds of expenses. So who should establish a special needs trust? I love this slide. It says caregiver or donor can establish a third-party trust for a child, sibling, or loved one who is disabled. That means a godparent can set up a trust, a mom, a dad, a grandparent. In some cases, the court can set up a special needs trust. And actually, believe it or not, in a very limited number of cases, the consumer with a disability can actually set up the special needs trust. That surprises most people, and that's recent. It's only been in recent years that an individual with special needs who has capacity can actually establish their own special needs trust. So anyone who asks the question, who will take care of them when I'm not around? And that's, of course, the theme of most parents when thinking about their son or daughter with special needs. How can I pass on part of my estate without affecting their government benefits? As we discussed before, we want to keep the government doing as much heavy lifting as possible. so that the resources we provide through the Special Needs Trust can be the everything else. I mean, few of us have enough money to leave that would take care of all the medical bills, you know, and all of their, again, all their food, shelter, and healthcare. Many medical treatments are expensive, and it would bankrupt us to attempt to pay them out of pocket ourselves. So it's a smart objective to have the government doing the heavy lifting and then have our resources, such as in a special needs trust, pay for or take care of what the government can't or won't. So the process for a trust is to coordinate available resources. In fact, it's just the conversation I had this afternoon with the family from Northern Indiana. I say, get statements together. Where is this 30 some odd $1,000 at? Please get statements so we can figure out where it's at. Therefore, once we have a special needs trust set up, then by having done an inventory of the assets that are a problem with Social Security eligibility, we can work on moving those accounts, those assets into the special needs trust. Ensure continuation of government benefits, so critically important. Provide supplemental needs for life, meaning quality of life. I remember a grandmother I helped plan some years ago who has since passed away, and she was planning for her grandson. So she had two daughters, and her husband had died, and one of her daughters had mental health issues, and so she and her husband, while he was living, ended up raising this grandson because her daughter couldn't handle it. And so her husband had passed away, and she knew end of life was near. And she came to me to plan because while she was very thankful for the government benefits, they were not going to focus on her grandson's quality of life. So we set up a special needs trust, and she managed through proceeds from the sale of her home to leave about $40,000 for the trust for her grandson. And she left her other daughter, the one that did not have mental health issues, as the trustee. And that daughter, after the grandmother passed, came to talk to me. She wanted to know what this trust was all about. And so we talked for about 45 minutes, all about her nephew, the grandson, and what he loved to do and what he talked about and so forth. And so then I said, well, thanks for coming in, and it's been great to meet you. And she said, but you didn't answer the question, what's this trust all about? And I said, it's about everything we talked about. Said, you told me he dreams about going to the Indianapolis 500. The trust can buy those tickets. That he loves the Pacers. Again, the trust could have him go to a Pacer game. And so we went on and on talking about all the things that she had talked about that he would love to do. And then she understood, because Social Security doesn't pay for that, and Medicaid certainly doesn't, but the trust can. The trust can give him things to look forward to, a reason to live, can enhance his quality of life. And so it's easy to understand why I'm so thankful for what I do, because, you know, when you can help create those kind of outcomes, it really warms the heart. So how does a special needs trust work? It stipulates how the monies contributed to the trust are used for the beneficiary. It states specific language. State-specific language is necessary. This does vary by state. Names a trustee, the person in charge of the trust. The trustee is obligated to act both by the trust document as well as with the interest of the beneficiary. And there are many ways that special needs trusts can be created to fit the needs of the family. So here you see a list of different types of special needs trusts. There is first party special needs trust, self-settled, Special Needs Trust Fairness Act, the third party special needs trust, qualified disability trust, pooled special needs trust, and a Miller D4B trust. Okay, believe it or not, we're going to unpack this one trust at a time. So hang in there with me, strap on your rollers.
Can I ask a question?
Absolutely. Thank you so much. I've been looking forward to this.
This is Beth Orlando. Back on your previous slide, you mentioned the individual states' specific language. What if they establish a trust in, say, Indiana and then later move to another state? Does it have to be redone, or what happens?
Okay, great question. And the answer is, if one moves out of state, then after a period of time where we can make certain that they're actually going to stay there, because sometimes our loved ones with special needs move out of state and then come back home, they may find they have a 10-year wait for a Medicaid waiver. They may find that they just can't get situated with direct service providers in their area. So in some cases, for a variety of reasons, they actually come back. But once it's determined they have moved to stay, then what we do is we will have a special needs attorney in the new state review the document to determine if it is good to go or if there are any amendments that need to be made to it based on state law and experience with the courts.
Okay.
In most cases, it is not a start over. In most cases, at most, it's tweaking or amending. It's not significant, but it's best to be safe versus sorry and have it taken a look at. We have, again, the network of attorneys that can help actually spread across the country. Most that we're familiar with are in Indiana and Kentucky. But while we're on that subject, not only do state laws differ, but government benefits differ by state. There are some states that pay a supplement to SSI. That is, you can get $794 plus extra money. And those states are the super expensive states like New York, Connecticut, California, et cetera. So there's a good reason they're giving you a little extra money. Also, again, I mentioned the Medicaid waiver program. So Kentucky specifically has something called the Michelle P. waiver. It's a waiver to die for. It has basically double the budget of the Family Supports waiver in Indiana, which is terrific. But we have a problem, and the problem is there's a 10-year wait. So you get your family member on the waiting list when they're 6 or 8, and you hope by the time they're 18 or 20, they're being targeted for the waiver. And unless they have unless they have medical involvement in their disability, there basically is no waiver available until you've waited it out for the Michelle P. waiver. So that's an example of why it makes sense to be careful about what state or states you may want to consider moving to. Kentucky is certainly not a bad state, but in the case of the Medicaid waiver, if that's a critical issue, services available through a Medicaid waiver, that may be cause to rethink whether moving to Kentucky is a good idea. Another state of concern is Illinois, and things are a bit of a mess in Illinois. It would definitely be one of the lower ranking states that a family with a member with a disability would want to consider moving to. So just some examples. Okay. All right. First party trusts. As you can see, we're going to go right down the list. So first party special needs trust is up first. It's a busy slide, so I apologize, but hang in there with me. First party Medicaid payback trust, self-settled trust, typically funded by monies belonging to or being received by the trust beneficiary, thereby staying under the $2,000 threshold to maintain eligibility for Medicaid, Medicaid waiver services, and SSI. So let's talk about this. So this, in other words, this type of trust is designed for the consumer's own money. That is, the individual with a disability, their own money or money that they are receiving. So this is not the first party or self-settled trust, is not the trust to be used by the grandparents that are wanting to leave their grandson or granddaughter with special needs $10,000 or $20,000 or make a gift of the same. This is a trust reserved for monies held by the consumer with special needs or money that they are receiving, okay? There is a difference. This is a default trust. A default trust means we use this trust when there are really no other options. And you'll find out why in a moment. In 2016, legislation was passed that enabled an individual with capacity to set up their own first party special needs trust. So that was a change that occurred going into 2017, that as long as an individual with a disability had capacity. An example would be they're an adult and there's no adult guardianship over them. Because if parents have gone to court to obtain guardianship for their 18, 20, 25, or 30-year-old with special needs or Down syndrome, then they do not have capacity. So they would not be eligible to set up their own self-settled or first-party special needs trust. Beneficiary must meet strict definition of disability. So if it's a first-party special needs trust, it can't be one of those where, you know, they maybe have a little bit of a struggle and we'll have to see how it turns out. One needs to meet the definition of disability for a first-party special needs trust. The trust is irrevocable. That means it can't be torn up and done away with. And beneficiary is generally under the age of 65. So this is the type of trust created to offload assets, not for an 85-year-old wanting to go into a nursing home and have Medicaid pay their bill, but for someone that is younger, under 65. Therefore, their need for the trust is related to a disability, not simply aging. After beneficiary's death, state is reimbursed, and here's the reason for it being a default trust, meaning we default to this when we have to, but a beneficiary, after a beneficiary's death, the state is reimbursed from the trust for Medicaid benefits paid during the lifetime of the beneficiary. This is what we call a Medicaid payback, as you see at the top of the screen, or a Medicaid lien. If you've ever heard of a mechanic's lien on a car, you probably know that means you can't gift the car away, you can't finance the car, you can't sell the car because there is a lien that has to be satisfied beforehand. So this is similar. Basically, the state has to be satisfied before any monies left in the trust could be paid to family members or that type of thing. Oftentimes, the Medicaid bill is so substantial that the state simply takes the balance of the trust account upon the trust beneficiary's death. The trust must exist for the sole beneficiary of the disabled person, meaning it can't be them and their 20 closest friends, and designed to supplement, not supplant government benefits, meaning to add to the quality of life or enhance the quality of life, not pay for the same things that the government would otherwise cover or pay for. Okay, this is a slide I just added an hour ago. So I'm pleased to give you many examples of where a first party or Medicaid payback trust can really come in handy, because knowing that there is a Medicaid payback, your reaction may be, well, I don't want that. But there are situations where this Medicaid payback first party trust is a godsend. So an example is a young person who I work with who's about 30 years of age, but at age 12, he was the victim of a traumatic brain injury. He was mowed down by an automobile that obviously left their lane, and the driver was impaired, unfortunately, and before their car came to a halt, the car had collided with this young boy at age 12, causing him to fall, strike his head on the pavement, and sustain a traumatic brain injury. So litigation followed, meaning the family on behalf of the 12-year-old sued the responsible party, and there was eventually a settlement. Well, as you might imagine, with a traumatic brain injury, the child had Medicaid, a Medicaid waiver, had government benefits. And if that 12-year-old, then probably 15 or 16, because it takes years to settle these cases, but nevertheless, if he had received the settlement, which was in the hundreds of thousands of dollars, because he was meaningfully affected, then he would have been rendered ineligible for any of these benefits. And what a shame if his settlement had to pay medical bills and hospital bills, and he never personally got to benefit from the funds. So that's an example where it's not somebody else's money, it's his money. He's the one that received the settlement. And so it would be appropriate for that to go into a first party or Medicaid payback trust. Example number 2, an age 32-year-old, this is this afternoon's call I was telling you about, with no government benefits. So this young man is 32, has no Medicaid. He has the Healthy Indiana plan, so basically similar to Medicaid, but no Social Security, and he's been appealing for years. So he has 30 some odd thousand. A first party or a Medicaid payback trust would enable him to set aside his monies and claim poverty in order to be eligible for the benefits. Another example is someone that was in my office this afternoon. Again, I eat, sleep, and breathe special needs, so I see cases all day, every day. So she is roughly 40 or in her early 40s, receives Social Security disability income payments. She also happened to have had a brain injury, and she also has Medicare, but she needs Medicaid and waiver, and therefore the first party trust was established in her case for her to transfer monies to, like, proceeds from the sale of her home and other things, so that she can maintain eligibility for Medicaid and receive waiver services. Specifically in Indiana, under the TBI, or traumatic brain injury waiver, and that waiver is handled through the area agencies on aging around the state. For Central Indiana, it's SACOA, Central Indiana Central Indiana Agency on Aging. So it's located near 86th and Keystone, and but that's example 3. Example 4, part-time employment and single, living with parents, saving money, but needs waiver services because the adult child was lived at home. They haven't had much in the way of expenses, and so they've saved money, but they need Medicaid. And so a first party trust might be a way for them to set aside their savings. Age 21 with a UTMA account with $40,000. This is a family from Southern Indiana I'm working with right now. And the daughter, who's about age 30, has no government benefits and has $40,000. So first party trust would enable the $40,000 to be set aside so that the 30 or so year old daughter could become eligible for Social Security, Medicaid, waiver services, etc. Unexpected inheritance of $50,000. So if someone dies and leaves $50,000 to an individual with Down syndrome, as an example, they're pretty well toast. But if that $50,000 is transferred to a first party Medicaid payback trust, then the government looks at them as not having the $50,000, even though it's sitting in the trust, invested and available to assist with needs the trust beneficiary has. A winning lottery ticket. Now, to be full disclosure, I have not had a consumer actually with a winning lottery ticket, but I have had a consumer with special needs that did gambling, sports gambling, and you hear the commercials and so forth. And so he did some sports gambling and actually won, and those winnings were considered an asset or resource, and he was about to lose his SSI, Medicaid waiver services, etc., believe it or not, because of his sports book gambling and winnings that he had received. So again, a first party trust enabled him to set aside that, I don't know if it was $6,000 or $10,000 or whatever it was, but set that aside to be eligible for benefits. Settlement received from an auto crash where Medicaid's at risk, another example. So all kinds of situations that occur daily where a first party special needs trust can save the day. Questions, please, because we're about to move on to third party. Questions about first party or self-settled special needs trusts. Okay, all right. And as I mentioned before, we assist with this. We have a network of attorneys that we work collaboratively with. We can help with all the issues that we're discussing. Okay, third party special needs trust. The main difference here is that third party special needs trusts are designed for anybody's money except for the consumer with special needs. So to back up a slide, first party is for money that belongs to the consumer with special needs. Third party is for everybody else's money. Everybody see the difference? First party, money belonging to the consumer. Third party, anybody else's money. And when I say anybody, I mean anybody. The neighbor, the friend, the godparent, you name it. Other people's money are welcome in a third party special needs trust. So again, varies by state law. Beneficiary and grantor and settler can be any age. Grantor or settler either sets up a revocable or irrevocable standalone special needs trust, which can be funded at any time or a testamentary special needs trust, which would only be funded upon their death. So it's possible either way. You can be set up where it can be used at any time, or it has to wait until the parent passes away. At the beneficiary's death, no need to pay Medicaid back. There's no Medicaid payback on this. So if it's properly set up and drafted and executed and managed, then it's possible for whatever is left in the trust upon the death of the trust beneficiary to stay with the family. So if there's $100,000 left in that trust, it can go on to their siblings or this type of thing. The funds can stay in the family, and does not provide at the bottom for basic maintenance needs like food, clothing, shelter. The government's focused on that. This is for everything else. Okay. Questions on third-party special needs trusts. This is the primary trust. This is the backbone for estate planning and for what parents and grandparents, this type of thing, want to utilize because there's no Medicaid payback with it. There's no downside to a well-funded special needs trust if it's a third party, because the money stays with the family. Hopefully interest, dividends, and income off of the trust can take care of the loved one with special needs, and then the trust corpus or principal can stay with the family upon their passing.
Gordon, this is Alan Sanderson. I just had a question. It says revocable or irrevocable. Why would you do one or the other?
Okay, again, thank you so much for the question. I appreciate it. And the answer is, it deals twofold. Some people want an irrevocable special needs trust because they get less trouble from Social Security. Social Security tends to have a love affair with irrevocable special needs trusts. So if you have revocable, they may question it. It is not, it's not a problem, meaning a revocable special needs trust is just fine, but Social Security is more likely to question it. The difference is if a parent, as an example, sets up a revocable special needs trust, then they can revoke it. They can undo it. They can take the money back out of it, do away with it. If it's irrevocable, then the funds are irrevocably assigned for the benefit of the trust beneficiary, and you can't undo it. That's why Social Security questions. So that's one issue. A second issue is whether or not one who is setting up the trust or serving as the trustee wants the trust to qualify as a qualified income trust, or shall we say a qualified disability trust. And we're going to talk about that on the next slide. So allow me to page forward. And this is where if a special needs trust is a qualified disability trust, it qualifies for special tax treatment, specifically an exemption for 2021 of $4,300. That means if a special needs trust is a qualified disability trust, the first $4,300 of interest, dividends, capital gains, etc., are not taxed. And so if the trust is large enough, then the settlor may want to set it up as a irrevocable trust, or if it's currently revocable, may want to make it irrevocable in order to have special tax treatment, as it would have to be irrevocable to qualify as a qualified disability trust. So a qualified disability trust has that exemption. The trust becomes eligible for qualified treatment as a result of several criteria. It's irrevocable, and many revocable special needs trusts can become irrevocable. And most often the trust documents provide the trustee with guidance as to what they would need to do to declare it irrevocable. The trust must be established for the sole benefit of the disabled beneficiary. And that's just an additional element that is not a part of the third-party special needs trust. But if the third-party trust is going to be a qualified disability trust, then it's going to have to be for the sole benefit of. The disabled beneficiary must be under the age of 65 at the time the trust is established, and the beneficiary must have a disability that is included in the definition of disabled pursuant to the Social Security Act. So you've got several criteria that have to be met for it to be considered in a qualified disability trust as outlined here. So those are probably the two major motivations. But by the way, even a revocable special needs trust typically becomes irrevocable upon the death of the settlor grantor. So if who sets it up passes away, then normally the trust becomes irrevocable at that time. So if a third-party trust, as an example, is revocable, but the parents who set it up die, it most often becomes an irrevocable trust, and the trustee could declare it a qualified disability trust at that point if it meets the criteria as described on this slide. Did that help answer your question?
Yes, it did. Thank you.
Sure. Okay. Qualified disability trusts are getting more popular. Part of that is because of tax issues. These special needs trusts are getting funded more often. We're setting up trust accounts every week. And as these trusts become funded with all kinds of different monies, we reach a point where the trustee has to start filing an income tax return. So obviously the question of, do we want it to be a qualified disability trust comes up, because it may not be to start with, but once it's funded, we start filing an income tax return and the trust has to start paying taxes. Would it make sense at that point to make it a qualified disability trust? Okay. Just a few other bullet points on the subject. The trust must be a third-party trust, not a first-party trust. Part of the reason for that is with a first-party trust is typically a flow-through, and the interest, dividends, and capital gains flow through to the income tax return of the disabled person. So it's a totally different situation. But a qualified disability trust, therefore, must be a third party funded with money not belonging to the individual with a disability. We typically, with a disability trust, qualified disability trust, we involve both a CPA and the attorney because it's a bit more complex situation. The trust must be sole benefit. The trust must be established. There's the age 65. And as most special needs trusts at the bottom are funded with the parent's assets, including life insurance proceeds and gifts from other family members, they can be established and treated as qualified disability trusts. This makes special needs trust even more valuable as a planning tool that is utilizing the tax advantage that comes with it. So, so just kind of tuck that in the back of your mind, but that can save up to $4,300 a year in taxes, depending upon how well the trust is funded. Okay, questions on qualified disability trust before we move on to pooled trusts? Okay, thank you for those that have asked questions. I really appreciate it. Pooled special needs trusts. These are typically established and handled by nonprofits, 501c3s, like Life Plans of Kentucky, or here in Indiana, the ARC of Indiana is known for their master trust. The assets are pooled, but assets deposited for each trust beneficiary are accounted for separately. Upon death of the trust beneficiary, remaining assets can go to the nonprofit, to Medicaid, or to the family, depending upon the type and design of the special needs trust. The pool trust serves as the trust, and the nonprofit provides trustee services. This type of trust at the bottom can be less expensive, working best in cases where resources to fund the trust are modest and or parents are unable to find a successor trustee. So if there's not a large sum of money, then the ARC can be helpful in two ways. Number one, it can be thoughtful in terms of what it approves in the way of expenditures, meaning it can hold the funds back a bit, not allow it to be spent too quickly. And then second of all, in the case of the ARC, and is the case with some other nonprofits, because some of leftover money upon the death of a trust beneficiary can go to the ARC, and in the ARC's case, they take 50% of first party or trust number twos, or at the family's discretion, may be able to receive a part from trust number ones. But these funds, the ARC will attempt to use for individuals whose trusts run out of money. So again, there are some situations where the ARC can be a good fit. It's not a one size fits all. And so a part of what we do is to evaluate family situations to determine what may be an appropriate fit, having an attorney draft a trust, utilizing the ARC trust, and so forth. Typically, the cost between the ARC trust and a special needs trust that we have an attorney draft is not significant. Part of that is because the attorneys we work with are very reasonable with their fees. It's really quite remarkable. An example is I was on the phone this morning. It was quite a day on the phone with an attorney this morning from Louisville. So the attorney has a special needs elder law practice in Louisville. And I was reviewing a situation with him on a family from southwestern Kentucky, close to the Illinois, Tennessee, Missouri line or whatever down there, quite a ways away. These days, with things being done virtually, it almost doesn't matter where you're at. So, but this is, believe it or not, a single mom who has adopted 5 children, and 3 out of 5 have special needs. Again, I'll repeat that because it's just almost hard to believe, but a single mom adopting 5 kids, 3 out of 5 have special needs. And so it made me curious, and I asked her, and she confirmed it, that she herself had been one of 8 children, 6 biological and 2 adopted. And so she was well familiar, having grown up in a home where adopted children were, were there. So, but I, in follow-up, because her resources, of course, are strained, my goodness, taking care of that many kids, et cetera. And three of her 5 children are going to need special needs trusts. So you can kind of start to do the math and imagine it could be financially crushing. So fortunately, because of the large amount of special needs work that we do, I reached out to the attorney I was talking with in Louisville, and we were able to, in that situation, get for that single mom a will, a durable power of attorney, a healthcare directive, a living will, her HIPAA acknowledgement, provision for the 2 without special needs, and 3 individual special needs, standalone special needs trusts, all for $1,500. I got to tell you, that's incredible. Most any other major firm in Louisville would have wanted north of $3,000 for that. And so I'm so thankful for the wonderful network of attorneys that I have cultivated over the years, their heart for special needs and what we're able to get done for families. It's so encouraging. It really warms my heart. So it's an opportunity for me to mention that we help families regardless of their situation, and that special needs planning is in no way limited to the wealthy. So whether it's a single mom like we just talked about, or a situation where maybe 2 parents but only one is employed, again, the objective is to help families, and so it feels good to help a mom like that that's doing so much for the children. Okay, so that's pooled special needs trust. Questions on pooled special needs trust before we go to Miller Trust?
This is Beth Rolando again. I don't have a question on the pooled ones, but I do have a question just sort of in general. You had mentioned that the trust can be set up to be established at, say, like if I set one up and in the will, how does that work to be established? Like it say is at my death versus setting it up beforehand.
Right. Okay. So
Did that make sense?
absolutely. Yeah. So 23 years ago, when I launched my practice in special needs, testamentary special needs trusts were common. And that's because the trusts were new. They'd only been around for 2 or 3 years, and they were new. And most people thought only, or thought in a limited way, of special needs trusts as a way to leave money upon the parent's death for their child with special needs. And so then what happened is we had, oh goodness, we had grandparents that started asking questions. And what we found, Beth, was that the testamentary trusts were very limiting. And that's because a testamentary trust, which is the special needs trust that is created out of one's last will and testament, basically is under wraps until the person dies. Are you with me so far, Beth?
Yep.
So what that means is that the only person that can participate in the club is you, and only upon your death. So there are a few families out there where I meet with them and the parents react saying, no, there's no one that is going to help. We'll be lucky not to be paying everybody else's bills before it's over with. And so they just don't see any way possible that anything is going to be done with the trust before they die. And in that situation, perhaps a testamentary special needs trust would work. But otherwise, over the years, the standalone special needs trust, whether revocable or irrevocable, have really become the mainstay, because if it's not buried in your will, then you can decide to put money in the trust if you care to, maybe from Social Security funds that come to you to reimburse you for the food and shelter expense that you're incurring on their behalf, or whether you just decide that, you know, you're setting aside $1,000 a year for the siblings' education and you want to put $1,000 a year into their trust as well, or grandparents get out the checkbook or want to leave money to the grandchild with special needs and incorporate that special needs trust into their estate plan. And the list goes on and on. There are just so many ways to have funds available to fund these special needs trusts that these days testamentary is more the exception than the rule. Now, a testamentary special needs trust is going to be a little less expensive. However, as I mentioned a moment ago, with the volume of special needs work that we do, and in the last 23 years, we've worked with about 3,000 families. We have been able to create, you know, estate planning options for families that are very affordable. And in some cases, attorneys that will take a payment plan over 12 months. And so all that a standalone special needs trust does has in some ways almost made the testamentary trust obsolete. Now, some families come in and they did planning some years ago and included a testamentary trust in their plan. I think it's wonderful. We may decide we want to pull the trust out of the will and make it a standalone trust if there's any interest in funding it before the parent or parents die. The other situation are blended families, and that's where perhaps the mother and the father of the child with special needs divorce. Perhaps they're now single or remarried. And if there is cooperation between the parents, it is possible, and I'm working with this situation right now with a family where the mother, who's the custodial parent, is in Louisville, and the father lives in Northwest Indiana and works for United, you know, up there in the Chicago area, United Airlines. And so he is actually setting up a special needs trust. They're divorced, obviously, they live separately, but he's setting up a special needs trust, and he's standalone special needs trust, and he's making his ex, the custodial parent, the mother that lives in Louisville with the children, a co-trustee. Well, that's a situation where a testamentary trust would not work, because if he set up a testamentary trust, nothing can be done until he dies, you know, and unless he predeceases the wife, it's very limiting. So we're seeing, even, like I said, divorced parents coming together for special needs trust situations and all kinds of creative things that we're doing. I'm sorry for such a long-winded answer.
That's okay. So if there isn't anybody else that's going to put anything into it other than, say, me, then You know, because
No.
I have it in my will and I was just curious as to if there was some way to, if I would.
Right.
consider
So
changing-
you've done that, and I've taken 5 minutes of your time and everybody else's to just totally tear it apart.
No, I just was just curious as, you know, because like I didn't realize the standalones, but like, but like I said, in my situation, I doubt seriously there's anybody else that's going to put anything into
Okay.
that trust.
Right. So here's the other aspect of it, and there's no
But how
crisis.
do they set up, you know, when you die? Is it like
Yeah,
automatic
yeah,
or does
right.
the beneficiary, or not the beneficiary, but
Right.
your executor have to deal with
Okay.
it?
Yes, a combination of your executor and the trustee who you've designated to be the trustee upon your death at the time the trust gets funded. So there's a couple of things there. The last thing I'll mention is a reason to consider a standalone versus testamentary is because we as parents get older. I know nobody believes that. My son with special needs turned 26 on Tuesday, and I'm like, oh my gosh, wow. But nevertheless, we get older, and there may come a time where you want to introduce the trust to an adult sibling of your child with special needs. So you can certainly inform them about the testamentary trust. If it was standalone and you chose to maybe put $1,000 or $5,000 in it or something, then you could make the adult sibling the trustee as you fade, and then they would already have experience with the special needs trust, already have an account set up, check writing, credit card, debit card, electronic bill pay. In other words, they could already be, handling trust issues while you're still around, kind of provide for a transition versus, as you just mentioned, how does it all happen at the time of your
Yeah.
death? Are you with me so far?
Yep.
Okay, but let's say you stick with the current plan and this all happens at the time of your death. So the answer is it depends upon where the money is coming from for the trust. So as an example, if probate assets are going to fund the testamentary trust, meaning proceeds from the sale of your home, monies from your checking, your savings, sale of your car, stock certificates you have or government bonds, then the executor is going to be involved because those are probate assets, and the executor is going to be involved with selling the house, liquidating the bonds, yada, yada, yada. And the executor would coordinate with the trustee, basically making assets available, and then per your instructions in your will, distributing assets on a pro rata or percentage basis based on what your will calls for to the trustee to be deposited into the trust account the trustee would then set up. Are you with me so far?
Yes.
Trustee would then obtain, with the help, hopefully, of somebody that knows what they're doing. I mean, all of this really needs, to have a special needs attorney, a special needs planner like myself involved, but I would be reaching out to the IRS, obtaining a tax ID number for the trust so that a trust account could be set up under that tax ID number. And then that trust account then could start receiving assets as distributed from the executor of your estate. We may also have other assets coming in because of beneficiary designations on life insurance, retirement accounts, investment accounts, et cetera. And so there's that component as well that may derive directly from financial institutions to the trust, bypassing your estate entirely. Okay,
Oh,
I'm sorry, I know that was a lot, but oh well.
Nope, that helped. Thank you.
All right, I'm so glad. All right. The pool trust serves, oh, well, we've done this. All right. Okay, now Miller Trust, sorry. OBRA 93, that Omnibus Budget Reconciliation Act of 1993, also brought about Miller Trust, the D4B Trust, also known as a Qualified Income Trust. And the use of this in the special needs community is cutting edge. This is like 2021 stuff. This is probably the first time any of you have heard about Miller Trust, period, or especially Miller Trust for individuals with special needs. So it's an irrevocable trust set up to receive monthly income in excess of $2,382 allowed to maintain disability, Medicaid, and Medicaid waiver services. Now, you may or may not have been aware that there was an overarching income ceiling. So there are 3 numbers that you want to keep in mind from all 4 of these workshops. The first number is the SGA, or Substantial Gainful Activity Limit number, which is $1,310 per month in 2021. That is the maximum amount of earned income, an individual with special needs should be achieving Otherwise, they are going to rot a lot of trouble. $13.10 per month. And it typically allows them to work half-time, 20, 25 hours a week, this type of thing, depending upon their hourly wage. So assuming they're not earning $15 an hour or something, then again, half-time usually works really well, et cetera. That's one limit. A second limit is the $2,000 resource limit, of course, for Medicaid, SSI, Medicaid waiver services, et cetera. And that's checking, savings, everything that, everything they have if they liquidated and piled it on the kitchen table. The third limit is the 2382. You may or may not be aware of this number. It's not talked about much because most people don't hit it, are not concerned about it. But in this day and age with our children with special needs, whether autism spectrum or Down syndrome, et cetera, outliving us, it's becoming a factor because children, as we talked about in workshop number 1, are living long enough to receive survivor benefits when parents die or adult child benefits when they retire. Now, within my lifetime, adults with Down syndrome did not live long enough to receive adult child benefits, meaning in most cases, the adult child with Down syndrome did not live long enough to see their parents retire. It sounds unbelievable. But as recent as the 80s, the life expectancy of an individual with Down syndrome was under the age of 30. And you'd say, how is that? That's just plain crazy. And the reason is, yes, advances in medical care, solving heart issues, near birth, et cetera. But a big part of that is the societal shift away from institutionalizing our citizens with special needs and instead giving them educations, investing in them, giving them reasons to be involved in the community, activities like Special Olympics and just all the things that give them a reason to live, a reason to look forward to tomorrow, et cetera. And bingo, the life expectancy more than doubles. Downright amazing. And now we're seeing individuals with Down syndrome living into their 70s. And unless you as a parent plan to live into your hundreds, they're going to outlive us. It's going to happen. So as a result of that, they're living long enough to see us retire and therefore to be eligible to draw off of our retirement records with Social Security. Sorry. So this is huge. This is really huge. And so we have families in almost every day where we're assisting them, primarily families where the parents are in their 50s, 60s, maybe 70s, but where they are either approaching retirement, they see retirement on the horizon, or they're right at retirement. And so this is a hot topic for them. And it really pays, the earlier the better. And it's all the more reason to take advantage of the free follow-up consultation, because we can look at your Social Security reports, do some mapping, some preparing on who's going to draw off of who and off of what record, and how we can maximize these monthly Social Security benefits to the tune of $5,500, $6,000 or more dollars per month. It's amazing. And the timing could not be better as fewer and fewer people benefit from defined benefit pensions. But this, again, is powerful stuff. So let's look at a couple of examples as how the Miller Trust factors in. Example 1, Daniel has special needs and is employed, earning $1,000 per month. So he's doing really, really well. He receives $458 per month of SSDI and $336 a month of SSI. So we add all this up together and he's totaling almost $1,800 a month. So you may be sitting there scratching your head saying, wait just a minute, this doesn't make sense. I thought you said he was working, earning $1,000 a month. So he obviously would not be eligible for Social Security. Well, surprise. The 458 is a benefit he draws off of his own wage history, nothing to do with the parents. Believe it or not, even at $1,000 per month in earned income, the person Daniel could still be eligible for some amount of SSI. So again, he's pulling in almost $1,800 per month. So earned income is under the $1,310 we just talked about. So life is good, right? His total income is under the $2,382. And again, you might be asking, now, wait just a minute, what does the $2,382 have to do with? That's the disability Medicaid limit. If somebody goes over $2,382, then they are subject to losing their Medicaid waiver and their disability Medicaid. So that's what's at stake for the 2382. Just little items like Medicaid and disability Medicaid and Medicaid waiver services. Yeah. So if he stays under $2,000, all is good. But in 2021, because keep in mind, of course, Daniel's an adult, he's working and so forth. But in 2021, his dad retires, making Daniel eligible for adult child benefits, meaning Daniel can draw off of his dad. His total SSDI benefit increases to $1,500. And you may be like, whoa, wait just a minute here. That's not unusual. We see adult children with disabilities drawing as much as $1,500 from a parent's record. Of course, the first thing the parent asks, understandably, is, wow, so does that come out of my Social Security payment? Get it?
Okay, good.
And the answer is no, it's over and above, it's in addition to. And isn't that amazing? It's a break for special needs families that other families don't have a clue about. So yes, you heard it here. It is possible for that parent, that mother or father, to draw $3,000 a month in Social Security retirement benefits, and for their adult child like Daniel to draw $1,500. That means between those two individuals, we're talking $4,500 a month, $54,000 a year in Social Security benefits just for the two of them. That's like unbelievable. Now, as a result of his drawing the $1,500, he's no longer eligible for SSI. So his total monthly income is now $2,500. His $1,000 in earned income and the $1,500 he's drawing from his dad. 1,000 plus 1,500. Now Daniel's got $2,500 a month. Wow, that's amazing. But there's a catch. He's exceeding the $2,382 by $108 a month. That's a problem, because that could result in his loss of his Medicaid and his waiver as well. If a Miller Trust is set up properly, I might add, to receive any monthly income in excess of $2,382, in this case meaning the $108 a month thrown into a Miller Trust account, then the government looks at him as meeting that 2382 requirement, and he gets to keep everything. You heard it right. He could actually have $2,500 a month in income, keep his $1,500 in Social Security disability, keep his $1,000 a month paycheck, his Medicaid waiver services, his Medicare, all of that, gets to keep it all. You know, hey, not a bad deal. Pretty amazing. But it's understanding the workings of these government benefits. That's why I really encourage people to come see me, because otherwise, without knowing how to juggle and balance these things, there's a lot that can be left on the table. Example 2, Ted has special needs and both parents die in an auto accident. He works part-time, earning $700 per month. His adult child survivor benefit is $1,800. Same problem as Daniel above. He's at $2,500 a month, $1,800 survivor benefit from the parents, $700 from his part-time employment. And yes, I can tell you of multiple examples right now where an adult child with special needs is drawing in the neighborhood of $1,800 per month as a survivor benefit off of the parents. So the stakes are really high with this stuff, because if you've got Medicaid paying your medical bills along with Medicare, and you have Medicaid waiver services, and you've got $2,500 a month coming in, and you're paying little to nothing in taxes, this is powerful stuff, let me tell you. This takes the pressure off special needs trusts. So the special needs trusts get to pay for all the extras: travel, vacations, cruises, basketball games, Indianapolis 500, concerts. I mean, you know, we can offer up a great quality of life for our loved ones with special needs by marrying these government benefits with the planning that we do outside of the government benefits. I hope some of you are getting excited, because every time, no matter how many times I go through this, I get excited over what we can accomplish advocating for our children. Trustee responsibilities, and we're going to have to bring it home. Oh my gosh, it's 8 o'clock. I guess I've gotten too excited. Okay. So trustee shows responsibilities of family, the trustee, and then government benefit agencies and social workers. Methods for funding the trust. Money can come from all kinds of places. gifting lump sums, annual or monthly payments, life insurance via the trust being listed as a beneficiary, retirement funds be a beneficiary. And this is powerful too because of the Secure Act that was just passed last year. Our kids, when they receive our leftover retirement money, are going to have to take it in 10 years and pay taxes on it. Not our child with special needs. If they have a special needs trust and it qualifies based on the criteria, and they can, whatever share goes to the special needs trust, they get to draw out over a lifetime, unlike their siblings who have to take it all and pay taxes in 10 years. And what really is ironic about this is traditionally, some planners had steered away from putting qualified funds into a special needs trust. I say no more. With the tax advantage of being able to draw out over a lifetime, that helps to minimize taxes, not exacerbate it. So exciting stuff happening with this stuff. Oh, well, lots of ways to, again, and special needs trust can hold property, pretty much whatever a person can. Grandparents can get in on it, caregivers, anybody. They can make gift of appreciated investments, meaning if grandpa bought Amazon at $100 a share and it's trading for 300 and he's thinking, man, I'd like to help out my grandkid, but gosh, if I cash out that stock, I got a big old tax bill. The stock can be gifted to the special needs trust. The special needs trust takes on the basis of the stock. There's no tax liability to the grandparent. Again, amazing stuff that we're able to do. And we work with this stuff every day. Payments can be made annually. We have some kids with special needs. Shoot, between parents and grandparents and aunts and uncles, we may have 6 different people depositing $50 a month into the trust. Do the math, that's like $300 a month, almost $4,000 a year. In no time, these trusts are $10,000, $20,000, $30,000. It's pretty exciting stuff when we get multiple people, weighing in as a community, trying to help our loved ones with special needs. Life insurance by way of beneficiary, absolutely. Your group life, your term life, different life insurance coverages. We can assist you in getting the very special language into the beneficiary designation. So as we were discussing earlier, the insurance company pays to the trustee of the special needs trust. No problem with benefits. It's awesome. This just gives you an example of types of life insurance to fund the trust. Life insurance can be a great tool because of the tax advantages. That is, life insurance creates a tax-free benefit and there's no reduction for taxes or otherwise. So pretty powerful. I do want to mention survivorship life. Let's see here. We use that a lot for special needs trust funding with 2-parent situations, second to die. That's noted there. We do a lot with that. We're almost done. We're wrapped up with less than 5 minutes. This takes us back to what the government helps with versus what the special needs trust does. Because some people are like, well, doesn't the government take care of everything? What do we need a trust for? And the answer is look to the right. Dental and medical things that the government won't pay for, gifts on special occasion, professional fees, vacation, trips, entertainment, education, other services. If they need to see a psychologist and Medicaid won't cover it. Again, personal hygiene, grooming costs, just all kinds of things that special needs trust. I see it because I see the disbursements going out of the trust that I manage every day. Okay, you can have a trustee. Trustee can be a parent, can be an attorney that sets up the trust, or you can have a trust department like at a bank or Mass Mutual Trust Company. There are a variety of options, so do not think that because you can't think of someone immediately to be the trustee. We figure it out, we get it done, not a problem. Okay, the process instead setting up a trust, step by step, we gather what we may look at for funding the trust. We decide if we're doing a pool trust or an attorney drafted trust. We get a draft of the trust, we review it, make sure that everything is set. We look to include other documents as a part of the estate plan. And then we work on funding it and announcing the trust to family. Because once you have a trust, you can announce it to anyone and everyone you want to and see who wants to help. I've had a few people announce it to GoFundMe and have actually raised money through GoFundMe to fund the special needs trust for their son or daughter. Pretty exciting stuff. Okay, I'm going to speed to the end here. I promised the last slide would have the contact information. So we started at 6:35. We're finishing at 8:05, so 90 minutes, boom. The email at the bottom of the screen, gholmes@financialguide.com. You can use that email address to request your free follow-up consultation. that or respond to one of the pre or post workshop emails that you receive. I know tonight was loaded, a ton of information. I hope, very much hope that it was presented in such a way that it made sense, because I know it was a lot of information. Please, please, please take advantage of the free follow-up consultation so we can look at how these concepts can be put to work for you and your loved one with special needs. Any last minute questions as I come out of screen sharing and back here? Okay. And
Yeah, I
we'll-
have one. Can you have more than one trust? Like, can I have a third-party trust and a Miller's trust?
Absolutely, and that is most common. Most common is to have more than one. Rarely would it be a Miller trust only. Usually a combination of third party and Miller, very popular. It's even possible to have three, a first party and a third party and a Miller. First party, if the consumer themselves has money we need to do something with. Third party for everybody else's money, and then to deal with the income issue with the Miller trust. Again, this is why I'm so thankful for the network of attorneys that I work with, because we can get stuff done without it being financially crushing. If you called a major law firm and, kind of got into the high rent district with this stuff, you could rack up thousands of dollars in fees and costs. But again, I'm very thankful for the attorneys that I work with. Their heart for special needs, and we figure out a way to get it done. But thank you for the wonderful question. Wonderful. Other questions?
Can a business be put inside of this trust or one of these trusts?
Yes. I dealt with that situation last year, right before COVID, right at the beginning of COVID. Actually a family-owned business in Southern Indiana. And the business actually had to do with the young man with Down syndrome speaking at events and receiving honorariums. And a book is in the process of being published with this individual with Down syndrome story. So basically we're looking at a business situation, and they were like, how could he benefit? How could the person this is all about benefit without losing benefits and so forth? It's like their heads were exploding, because we're doing this because the story is too good to keep secret. And yet it's, it just does not make sense that his story could not benefit him. And so, yes, so it is possible, to answer your question, to for the trust to hold businesses or that type of thing. Thank you so much for that question. Other questions, please. I'm just so thankful for all of you participating. There are a few things that I do that I enjoy more than sharing. All right, well, if there are no more questions, then just a quick plug for next week. Next week is going to be great for questions about anything that we've covered. We'll be talking about life care planning, person-centered planning, and kind of a broad brush review of all that we covered during our journey together through the month of May. Again, I want to personally thank you for setting aside time. I know we're all incredibly busy. So God bless you, and we'll look for you next Thursday. Good night.
Thank you. Good night.
Thank you.
Thank you, Gordon. That's been great.
Thank you.